All right, 11 a.m. I think we can get started. Good morning, everyone, and welcome to this webinar by SA Prime Trustees. The purpose of this webinar is both to introduce you to SA Prime Trustees, as well as discuss a bit about some of the topical issues facing trusts at the moment. We're very happy to have the chairman of SA Prime, Professor Walter Geach, presenting the webinar today. Professor Geach is one of these rare people that is both a chartered accountant as well as an advocate. He is someone that's very well known in both the corporate sphere as well as the academic sphere. He's authored or co-authored over 15 books. He was previously the head of accounting at the University of the Western Cape. He also serves as a director on boards of various listed companies and has acted as an expert witness in various court proceedings. He is the chairman of SA Prime Trustees, and we're excited to hear a bit more about what he has to say. Just as a bit of background, so SA Prime Trustees is essentially a fiduciary services company. You know, the topic of trust is something that's very topical at the moment. It's something that is consistently or continuously being mentioned by SARS and by Treasury. It was mentioned in the Davis Tax Committee reports a few years ago. Every year in the budget speech in the review, they mentioned that SARS are going to pay more attention to trusts. Every year in the SARS strategic plan, they mentioned that they're going to pay more attention to trust. So that the timing is imminent that that SARS are going to be looking at trusts a lot more closely, looking at things like how the distributions are declared, whether trust may be alter ego trust, and all these types of things that Professor Geach is going to run through with us. So we've identified that it's imperative that people who have trust within their sphere use a reliable fiduciary services company to assist them, and the assistance can take many forms. What we do under SA Prime is consulting, so we can do reviews of current trust deeds to see whether they're fit for purpose or whether there's any risk there. We can help with both the administration and management of the trust, so making sure that you know, all your obligations in terms of the Trust Property Control Act and as well as the Tax Administration Act are adhered to, and that includes assisting with tax compliance, preparation of annual financial statements. And then we can also assist with the acting as an independent trustee. So the independent trustee, as Prof. Geach will talk about, is something that is very topical in South Africa and around the world. An independent trustee is not someone that you know, that should be there merely to just sign documents and follow on whatever the founder of the trust does. It's someone that needs to take an active role in assisting with the governance of the trust, and so we can provide that service through our various directors at SA Prime Trustees. In terms of a few logistics for us today, we are on the Zoom meeting platform, so we just ask everyone to make sure that you are on mute the whole time through. I do have the power to mute you if you go off mute, so I will be able to do that. We do have people joining from all over the world, so for bandwidth issues, we ask you, if you don't mind, to just keep your videos off. But if you'd like to have video on, it's not too much of an issue. If you have any questions, we are going to have a 10 to 15 minute question and answer session later. We've got 170 people on the meeting already, so I don't think we're going to have the capacity to do vocal questions. So we ask you to just put your questions in the chat function in Zoom. You can either direct them directly to me or to the general chat function, and we'll pick them up from there. And then the last thing I just wanted to mention on logistics, something I've recently found out on Zoom, is if you look on your top right-hand corner in the in the little view block, you can switch there from the standard view to a side-by-side view, and that gives you the ability to move how big you want the presentation and how big you want Professor Geach's face to appear on your screen, because we're not all here just to see the words, we're here to see the people as well. So look forward to today, and hope you all see real benefit from it. And with that being said, I'm going to move over to Professor Geach to start his presentation.
Good morning, everybody. Thank you very much for joining us. It's a great pleasure and to have so many people, and it's an exciting seminar. And I'm going to start off, that is our seminar content. I'm going to talk about trustees, and as Graham mentioned, certainly the issue of independence is an important issue there. And then the next topic will be when assets are put into a trust, either when it's formed and subsequently after it has been formed. What is the nature of the transaction really that causes that asset to be put into the trust? Is it a donation? Is it a sale on loan account? It's very important to actually specify the nature of that transaction, as I will show you just now, because there have been some awkward cases where it hasn't been specified and it causes all sorts of problems. Then the question of a removal of a trustee. I'm sure there are lots of people who would love to remove some trustees. Can it be done? We will discuss that in some detail. Then when contracts are concluded with a trust, sometimes they're not enforceable. And as some court cases have said, when you contract with a trust, you enter into perilous territory. So if you're a third party and you're dealing with someone's trust, what must you do to ensure that it's a valid contract? So we'll explore some issues there. The identification and description of beneficiaries is absolutely critical, because a trust without a beneficiary is a nullity, and this causes severe problems. And then it's the question of discretionary beneficiaries. People think that discretionary beneficiaries don't have rights, and we will discuss that, because discretionary beneficiaries do have rights. Then we're going to look at trust amendments, a very important area. And I'd like to put Potgieter's case into context, because a lot of people think that if beneficiaries have accepted the benefits of a trust, then their consent is necessary for amendments. And this is not always the case. So I need to clarify that. And then there's questions and answers. And I've been looking at some of the people who've joined, and I'm very happy to see we have some very good trust specialists. Hello, Fear, for example. So if I can't answer a question, guess who I'm going to start asking? So welcome to the seminar, and I hope you all enjoy it. When it comes to, and I just need to, the independence, appointment of trustees and trustees' duties, we're going to chat about that to start with. And so a very important distinction is the appointment of a trustee compared with the authorization of a trustee. The trust deed appoints trustees, generally speaking. If they don't, if the trustee doesn't, the master will. So a trust will never fail for lack of a trustee, unlike lack of a beneficiary. But the appointment of trustees is generally done in terms of the trust deed. The authorization of trustees, however, is a different issue altogether, because that is done by the master's office. And it's a critical issue to realize that if the master has not issued letters of authority, that person cannot act as a trustee, and any actions are null and void. They're not ratifiable, they're just null and void. And I have seen in many trust deeds where the trustees have the power to have alternate trustees or the right to appoint a proxy. And quite frankly, those clauses are not valid, because you can only act, or the proxy or alternate can only act if authorized by the master. So those sort of clauses in a trust are quite misleading. So be very careful of the question of authority. And it's been held quite a long time ago that if a person acts without authorization of the master, there are no legal consequences. And as I said, it's null and void, it's not ratifiable. So it's very important when you ever contract with a trust to get the letters of authority is absolutely critical. The Chief Master's Directive has, in no uncertain terms, says the master must consider, that's the various masters in the various regions, must consider appointing an independent trustee. Basically, if the trustees have power to enter into contracts with third parties, the trustees are all beneficiaries. In other words, there's a mirror image of trustees and beneficiaries, and the beneficiaries are all related to each other. This sort of setup in a trust is very dangerous, actually, because if trustees are also beneficiaries, do you in fact have a trust? Just because you call something a trust doesn't mean to say it is a trust, because some of these business trusts that I've seen are in fact partnerships. And it's very different from thinking that you're a beneficiary of a trust. Meanwhile, you're a partner in a partnership, jointly and severally liable for the debts of that business. So in terms of the Master's Directive, an independent trustee must be a person who realizes the responsibilities of a trustee. And the responsibilities include the duty to act with care, diligence, and skill, amongst many other things. The important thing is the independent trustee does not have to be a professional person, but must certainly not be a beneficiary because they wouldn't be regarded as independent. They must be competent to scrutinize and check the conduct of other trustees, must be knowledgeable about the law of trust, must have no interest, because you've got to be independent, you must have no interest in trust property. And you must also be aware that the failure to observe the duties of a trustee can result in an action for breach of trust, which can lead to personal liability. But the master can waive the requirement for the appointment of an independent trustee if the founder can show good cause to do so, or if security is provided. You don't want to go that route of security, or if an auditor is appointed. So sometimes it's just a lot easier to have an independent trustee, quite frankly, rather than have to go through 1, 2, or 3 over there. The master has a discretion who to appoint as an independent trustee, can be guided by the founder, trustees, or beneficiaries, but still has the ultimate discretion. Now, decisions of trustees are critically important. A trust deed must contain clauses dealing how trustees arrive at a decision. And the important point, no person who is a beneficiary must be seen to have control of the trust. If there is control, at the very least, you've got a deeming provision for estate duty purposes. In fact, it might destroy the whole trust altogether if there's control. It might be seen as a partnership, might be seen as all sorts of things. And a very important issue, if the trustees can act by way of a majority vote, there could be a very high risk. If, for example, there are 3 trustees and 2 of the trustees are beneficiaries, because those beneficiaries control the trust and it can destroy the whole trust structure and all the protections that go with the trust structure. And certainly, there's a very high risk if a settlor or beneficiary has reserved the power to dismiss and or appoint trustees, because that is giving control. And the big issue with a trust is just not suitable for a person who doesn't want to give up control. You have to give up control, otherwise those assets can be deemed to of the person who has control for estate duty purposes, for commercial purposes, or for all sorts of purposes. So you've got to give up control. I think it's a very important issue. So when you start looking at the duties of a trustee, if one looks at the various case law and the Trust Property Control Act, there are a lot of duties on trustees. Take minutes, that's the most important thing. I mean, I've seen so many people in practice, they don't even have trustee meetings, they don't take minutes. And you've got to take minutes, consult with other trustees, record the decisions taken. This is absolutely good governance. All loans to or by the trust must be authorized and recorded either as resolutions or preferably there should be a loan agreement. This is where a lot of trusts in practice fall down, because the record keeping and the keeping of loan account agreements and things like this, as I'll show you in some case law just now, is there a loan or is it a gift or what is it? The use of trust property must be properly justified. So in other words, if a trust owns a house and someone lives in that house, have a resolution granting permission, the trustee's permission for that person to occupy that house. Open a trust bank account. The TPCA, the Trust Property Control Act, If there's monies to be held in trust, you've got to have a trust bank. It's not a choice. Have an asset register. It's not a choice. It's a requirement of the Trust Property Control Act. Have all the documents as required by Section 17. Now, this is where many trusts fail because a lot of trustees don't even know what those documents are in Section 17. Have a look at those. It's a statutory requirement. And the most important thing is trustees must act with care, diligence, and skill. And I've seen so many trust deeds that say trustees are indemnified unless it's from their own fraud or theft. But you cannot escape the provisions of the Trust Property Control Act because you have to act with care, diligence, and skill, and you cannot limit those duties and responsibilities. And that is Section 9. You must act with care, diligence, and skill. And this is which can be reasonably expected of a person who manages the affairs of another. So think of who can be appointed as a trustee. So in this case over here, a trust owned a property which a third party wished to purchase. The offer was made by D was too low and was rejected. So one of the trustees offered to buy the property through a company controlled by him. A sale agreement was concluded and the property was bought by this company, Z company. So D wanted to buy the property, trustees offered to buy the property, and a sale agreement was concluded and the property was bought by this company, Z company. That same company, which was controlled by a trustee, 6 months later sold the property to D, that same D who wanted to acquire it originally. And Z company made a profit of approximately 20 million on the sale to D. A beneficiary of the trust sued, number one, the trustee and Z company. Now, this is really very interesting because Z made a profit and a beneficiary of the trust sued both the trustee and Z company. Can a beneficiary of the trust sue in this case? The court held that a breach of a fiduciary duty in relation to a trust may give rise to two different actions, one on behalf of the trust and the other by a beneficiary of the trust claiming in their own right. So what happened in this case? If an independent third party knows of a trustee's breach of the fiduciary duty owed to a trust and acts in a manner, so if a third party acts in a manner that aids the trustee's wrongful conduct, that person is liable to either the trust or the beneficiaries for the losses they have suffered. So third parties in these circumstances can be personally liable. So the Supreme Court of Appeal held that the third party in this case also acts wrongfully. The third party must share the liability of the person breaching the fiduciary duty. So you can't hide. If you've got a duty as a trustee, you can't go and form a company and then say it's got nothing to do with you. So there's a cause of action against the third party. Okay, that is the independence appointment of trustees and trustees' duties. When assets are put into a trust on its formation and subsequently, how are those assets put into the trust? Is it a donation? Is it a sale on loan account? What is it? So when trust acquires assets, does it result in donations, which will result in donations tax? Or is it a loan? And if it's a loan, there has consequences. So when a trust is formed and assets are put into the trust, the initial donation, basically you've seen with trusts, there's basically a nominal amount when a trust is formed. And it's usually either settle the trust, put in 100 Rand to be held by trustees in trust. That's how you form the trust. In this particular case, the 100 Rand wasn't put in. And they argued, the plaintiffs, that the trust was therefore not properly established and therefore never legally existed, and therefore they wanted to claim the assets so-called held by the trust. In this particular case, the High Court ruled that it is not an essential factor for the formation of a valid trust that the trust be properly transferred to the trustees. If no transfer happens, the trustees acquire the right to demand the property from the founder, but the trust is legally recognized once it's registered with the master and the letters of authority have been issued. So I must say this is very important that everyone understands if the trust will be legally recognized. So when the assets are put into a trust is a loan or donation. If it's a donation, is their donations taxed at 20%? If it's a loan, what are the repayment terms? It must be in writing, interest-free or interest-bearing. And then you've got section 7C, which is the continuing donation. So when an asset is put into a trust transformation, there's a sale agreement, there's a loan agreement, there are lease agreements. Let's have agreements and law agreements in place. In Van Staden's case, this was an application for the sequestration of a trust on the basis that the trust committed an act of insolvency as envisaged by the Insolvency Act, or on the basis that the trust was factually insolvent. What happened? The deceased would make loans and or donations to the trust for the purpose of funding the trust. Was it a loan? Was it a donation? It was uncertain whether the payments that were made by the deceased during her lifetime were to be regarded as loans or whether they were donations. So what is the nature of those transactions? So basically in this case, the court had to decide whether the deceased had donated an amount of R500,000 Rand to the trust, and or whether it was merely a loan entitling the executrix of the deceased estate to demand the repayment of the loan. You see the danger of not actually putting in writing the nature of a transaction. It must be very clear. Is this a loan or what is it? Is it a donation? If it is regarded as a loan, obviously, then it had to be decided whether the trust was able to repay the loan or whether it was insolvent, and then the trust could be wound up. And so in this particular case, it was argued that no such loan existed, and the 500,000 clearly was intended to be a donation, and it could never be intentional that the amount was merely a loan to the trust. And the deceased expressly made provision, the trustee, that in the event of her death, her children would be the beneficiaries of the trust. So the court held, regard must be had to the fact that the trustee provided that the deceased children would be the beneficiaries of the trust after her death. If it was intended that the 500 was a loan and had to be repaid, why then was provision made that her children would be the beneficiaries of the trust? Beneficiaries of what? There would be no assets in the trust and there would be no need for beneficiaries. So therefore, the trust found that the trust did not have a single creditor, and it followed that the application for the sequestration of the trust was dismissed with costs. And the respondent, in terms of this divorce settlement, was obliged to acquire fixed property to put into a trust, in this De Beers case, in which his ex-wife and the children would live in that fixed property. He did this, but arranged a loan account be established in the books of the trust in his favor for an amount equal to the cost of the property. The court held he was obliged to provide the house at his cost and was therefore not entitled to arrange that a loan account be established in the books of the trust in his favor. It's quite important because when you start looking at providing, for example, a house and putting it into a trust as part of an obligation, you can put it into a trust, there's no donations tax and there's no loan account. So you can put literally an asset into trust if it's in settlement of an obligation. It's a very important legal point. Removal of a trustee, sometimes very important for various reasons, but purely a conflict does not necessarily mean a conflict amongst trustees, doesn't mean to say you've got to get rid of them. So section 20 in brackets 1 of the Trust Part Control Act is very important because a trustee may, on application of the master or any person having an interest in the trust property, that is a beneficiary, by the way, a trustee may at any time be removed from office if the court is satisfied that the removal will be in the interest of the trust and its beneficiaries. So there doesn't have to be wrongdoing. It's only got to be if it's in the interest of the trust and its beneficiaries. In this particular case, it's a Supreme Court of Appeal case, 23rd of October, 2020. Recent. The legal principles include the following. Where there is disharmony, the essential test is whether it imperils the trust estate or its proper administration. Mere friction between trustees and beneficiaries will not in itself be adequate reason for the removal of the trustee. Neither mala fides or even misconduct are required. The critical consideration is the welfare of the beneficiaries and the proper administration of the trust and trust property. So this was a Supreme Court of Appeal case recently heard. And it was held a breakdown in relationship between co-trustees originating from outside the trust, so they don't get on outside of the trust. That in itself is not sufficient to remove a co-trustee. You've got to say, is the trust property and its affairs imperiled? It cannot be assumed because there's a lack of trust or respect or compatibility amongst trustees that the trust property is imperiled. The test is always whether it's incompetence, misconduct, incapacity, lack of trust, has it resulted in the trust property or its proper administration being placed at risk. So just because you don't like your co-trustee doesn't matter. There has to be something more. So basically, other than the master, a person can apply for the removal of a trustee only if he or she is a beneficiary of the trust. And that is a Supreme Court of Appeal judgment. And you can't, if you're a non-beneficiary, say you have a sufficient interest. And the grounds for removal might be unreasonable conduct, negligence, breach of trust, any kind of attitude like that. So in this particular case, the ex-husband bought a house for his ex-wife and children put into a trust. There was an application to remove him as a trustee. And the court said, in terms of 20, are you going to remove someone? You must act with circumspection. You don't need mala fides or even misconduct. The critical issue is, does the conduct of the trustee imperil trust property or its proper administration? And the welfare of the beneficiaries is all important, all important. And the court held the respondents present as a trustee was not important enough for the trust's efficient and successful existence. He wasn't making an essential contribution, and he was removed as a trustee because there was no real reason to keep him. So the important issue, if the relationship between co-trustees is broken down, they have no mutual respect for each other, this can also be brought under Section 21, for it could imperil the property, but it does not always have to be so. So trustees sometimes do not get on. It doesn't mean to say that that justifies getting rid of both of them or one of them. If neither of them are willing to step down, the court can remove one or both. And in this case, the court removed one of the trustees. And here, in terms of Section 21, where a court removes, there doesn't have to be proof of mala fides, dishonesty. But basically, this was Amachandra Banzi's widow. She was wearing two hats, and they were mutually destructive with conflicting duties. Therefore, the court removed her as a trustee. A very important issue is when contracts with a trust are not enforceable, because this is very important from a commercial point of view. Here, the bank advanced a loan to a trust and took security over movable property. So there's the loan and it's got security. The trust deed said there had to be 3 trustees. There was only one. The court held in no uncertain terms, when fewer trustees than the number specified are in office, the trust has an incapacity that precludes the borrowing of money or the encumbering of its trust assets. So the bank thought it had security. The security was null and void. So it's very important to see the number of trustees that are required and the number. And basically, the minimum complement essential for the lawful operation of the trust will remain lacking until the substitute, and that is the critical word, is authorized. Authorized by whom? Authorized by the master's office. In Vogel's case, the court held that while a sub-minimum number of trustees cannot bind a trust, but they must still observe the provisions of the trust deed and they have certain duties. And if one of the provisions for the sub-minimum to appoint a trustee is required, they are duty-bound to do so. So if a trust is supposed to have 3 and it's got 1, that's got a problem. The trust has got a problem. And that's why trust deeds should really have clauses that if you've got to have 3 trustees and it goes below 3, you must write in that trust deed that the remaining trustees, provided they've taken steps to appoint the 3rd trustee, they can still act on behalf of that trust in certain circumstances. In Wergel's case, and the trust deed provided there shall be not less than 3 trustees, and it had a proviso. If the number of acting trustees is less than the prescribed, the remaining trustees shall be entitled to exercise the powers for maintenance administration. So they couldn't do anything, but they could apply have duties, power for the maintain and administer the trust fund until another trustee is appointed. In this case, there was one trustee, and he sought to demand the payment of trust monies from a previous trustee. That previous trustee said, you can't happen because you've only got 1 trustee and not 3. The court held in order to maintain and administer the trust fund, he had to have possession of the trust funds, and that is what he sought to do through the application to court, and therefore it would be absurd to suggest that the applicant had the power to maintain and administer funds, but that if a party wrongfully had in its possession those funds and refused to hand them over, then the applicant could be impotent to act. So therefore, the court forced that person to hand over the trust assets. So the applicant did have the capacity to have brought the application. He was not seeking to bind the trust. He was merely seeking his obligation to maintain and administer the trust funds by seeking to transfer those funds into the trust bank account. Now, a very important principle when contracts with a trust are not enforceable. If a deed provides for it, it is sufficient if a decision enjoys the support of majority. But a majority is competent only if adopted by a majority of trustees present at a quorate meeting. And to qualify as a meeting, all trustees must have to receive notice thereof so as to be able to participate if they so wish. So you can say there are 3 trustees and a majority prevails, but all 3 trustees must know what's going on and be entitled to have an input. So the courts have said, Supreme Court of Appeal, a very important case, while it is permissible for trustees to authorize one of them to act on their behalf, it is a question of fact whether they have done so. And here it's said, it's a bit vague, the resolution empowered Mr. C to sign necessary documentation. The obvious question is necessary for what? The meaning is obscure, as the Supreme Court of Appeal actually confirmed. If you're going to give powers and certain powers on trustees, be very clear that it's well worded and there are no uncertainties. In this Supreme Court of Appeal case, what was the trustee's intention? Basically, the context to let one sign was the acquisition of a farm. And so the trustees, having resolved to purchase the farm, authorized Mr. C to sign documentation. That is fine. They did not confer on him the authority to conclude business agreements with other parties subsequently. So one must be very careful. This is a very important principle. So you can also get a estoppel. If actual authority has not been given to a trustee to act, is there ostensible authority or estoppel? There must be a representation by the principal, that is, the agent had authority to act. It must be in the form that the principal should have accepted, that third parties might rely on it. There was actual reliance by the third party, and there was resultant prejudice to that third party. In Costa's case, Supreme Court of Appeal, this fruit group could not reasonably have relied on a vague resolution passed some 2 years prior to the conclusion of agreements, and which did not refer to any contract, but only to the necessary documentation. Therefore, the contracts were not enforceable. So in other words, there was no contract. Right, this is an important issue, the identification of beneficiaries and the rights of discretionary beneficiaries. A trust without a beneficiary is a nullity. There are risks involved with testamentary trusts, because if you have a testamentary trust and you have certain beneficiaries, and all of those beneficiaries actually don't accept, then the problems are whose problem? Carefully describe and identify who the beneficiaries of the trust are. In this particular case, Supreme Court of Appeal, the appellants approached the court declaring that the words children, descendants, issue, and legal descendants used in the trust deed include adopted children. Does it include adopted children? The question raised in the case was the extent to which freedom of testation must yield to freedom from undue discretion. So it's a very important issue. The appellants contended that the High Court failed to take into consideration the radical developments which have taken place in our law. For example, the introduction of constitution. A very important principle comes up. The trust speaks from the time of its execution and must be interpreted at the time of its execution. It is the settlor's intention at that time when it was executed. It must be ascertained from the language used and subsequent events. And in these are included statutes cannot be used to alter that intention. And in this case, the deed appears to have been drawn up by a professional person. And if the donor had intended to benefit adopted children, he would presumably have been advised of the need to include such class of children in express terms. The court held that freedom of testation, but this is a very important comment by the Supreme Court of Appeal. Freedom of testation protects a person's right not only to unconditionally dispose of his or her property, but also to choose beneficiaries as that person wishes. Freedom of testation. The donor is free, therefore, to exclude adopted children if he wanted to. He was equally free to expressly include one or more of his biological children. And this is a very important principle. No beneficiary has a fundamental right to benefits, because a donor can exclude adopted children, can exclude biological children. And so it is suggested that a so-called out-and-out disinheritance can probably not be challenged on constitutional grounds, and the tester's freedom of testation should have priority in such a situation. Now, a very important principle is that all beneficiaries have rights, including discretionary beneficiaries. All beneficiaries have rights. And our law affords a contingent beneficiary the right to protect his or her interest against maladministration by the trustees. People think they are just discretionary, they're contingent, they've got no rights whatsoever. They are rights, and that is why when a person sets up a discretionary trust and has discretionary beneficiaries, the person who sets up that trust must make themselves, even though they're discretionary beneficiaries, must cause the trustees to consider their needs before the trustees consider the needs of other discretionary beneficiaries. So you can have preferred discretionary beneficiaries, in other words. In this particular case, Supreme Court of Appeal, again, a 2019 case. This trust owned shares in a company which owned land in a game reserve. All the discretionary beneficiaries over the years had the benefit of visiting that game reserve. The trustees then decided to refuse permission to one of the beneficiaries, DK, to enjoy the benefit in the future, because the family had issues with DK. DK was being not conforming to what they wanted him to do. So in the past, DK was a discretionary beneficiary and visited the land. It was argued that DK remained a potential beneficiary who merely had contingent rights and no vested rights, and therefore they had nothing to protect. It argued that notwithstanding the fact that the first respondent and other potential beneficiaries had previously been allowed to occasionally occupy the farm. No vesting of rights was consequence upon that occupation. So he's now not allowed to visit the farm. Does he have a right? Does he have a claim to keep visiting the farm? The Supreme Court of Appeal held a contingent beneficiary in a trust does have rights worthy of the court's protection, a very important principle. Hence, for example, our law affords a contingent, discretionary beneficiary the right to protect his or her interests against maladministration, whatever maladministration is. If you can allege and prove maladministration, you are protected, even if you're a discretionary beneficiary. In this case, the Supreme Court of Appeal held that trustees have an obligation to treat all the beneficiaries even-handedly. You see, once you've got discretionary beneficiaries, if you want to treat some discretionary beneficiaries better than others, write it in the trust deed. Otherwise, you could run this very real risk, as highlighted in the Supreme Court of Appeal. You've got to really treat all beneficiaries, if they're discretionary, even-handedly. You've got to have reasons why you want to actually favor one person rather than another. You can't just say, I'm favoring that one because this is the person who set up the trust and put assets into the trust. So your trustee should actually take some very careful wording where you're allowed to treat the beneficiary and all his or her spouse better than the other beneficiaries, the children, for example. So in this particular case, Supreme Court of Appeal said as a beneficiary, DK, who they're now saying you can't go to that farm, had a right to be protected against arbitrary and discriminatory treatment. And that is an important issue. And so the Supreme Court held in this matter the privilege of taking a vacation on the farm on the game reserve. It was taken away while the other potential beneficiaries, when I say potential beneficiaries, discretionary beneficiaries, continued to enjoy those same rights. This constituted differential treatment without a justifiable basis. And this is a very important principle because people sometimes think it's a discretionary trust and trustees can do what they want. Be very careful. If you're going to treat beneficiaries differently, have very good reasons why you're doing so. Just because someone formed the trust and is still just an equal beneficiary doesn't mean so you can just treat that person better than the other beneficiaries. If you want to be preferred, write it into the trust deed. So in other words, in a trust deed, when you look at the rights of beneficiaries, it can be like shares in the shareholders in a company. You can have preference shares, you can have ordinary shares, and you can have deferred shares. Same thing with a trust. You can have preferential rights, ordinary rights, and deferred rights. All of those can be under discretionary beneficiaries. So there's a lot of movement that one can do when it comes to rights of beneficiaries, very important issues. In Grissel, Supreme Court of Appeal, the Supreme Court held that the role of a trustee in administering a trust calls for an exercise of fiduciary duty owed to all the beneficiaries, whether they have vested rights or discretionary beneficiaries. While discrimination on the basis of need may be justified by the needs of a particular beneficiaries, the trustees in this case did not advance need as the reason for treating the first respondent less favorably. Very important. When trustees make decisions, it must be very well documented as to how they're arriving at those decisions, why they're arriving at those decisions, and do they have the power or are they prohibited from making those decisions. In Grissel's case, Supreme Court of Appeal, also 2019, it's clear from the averments made in the affidavits that the attorney's correspondence is regarded as obstructive and contrarian. That may be so, but that does not suffice as justification for treating him less favorably. This means that the trustees unfairly discriminated against him. So the quota quo was correct in reinstating his right to visit the farm on a rotational basis, even though the other trustees had issues with him. So he could not just, even though he's discretionary, he could not just have those rights of visitation of the farm arbitrarily just removed. Trust amendments is a very important issue, and we will look at this issue of trust amendments. The important issue, the trustees and beneficiaries of a testamentary trust cannot vary or amend the trust deed unless the trust deed specifically allows this to be done. So a testamentary trust, if it's quiet as to amendments, beneficiaries cannot agree amongst each other. The beneficiaries can renounce their rights, but can amend the trust. The danger of beneficiaries renouncing their rights, if you have certain beneficiaries and no clauses for if they renounce, it doesn't go to someone else. Basically, the beneficiaries, if they are beneficiaries and they renounce their rights, they can collapse the whole trust. Because in one case, that's exactly what happened, because the trust deed, testamentary trust, basically provided that the beneficiaries can't get any real benefits until they were 35 years old, to cut a long story short. So the beneficiaries didn't like this because they didn't want to wait till they were 35. So they renounced their benefits as beneficiaries, and it collapsed the trust because there was no one else listed as a beneficiary. So those very same beneficiaries then inherited on the grounds of intestate succession. So they got all the assets that were so-called going to that difficult trust. They got all those assets straight away because they renounced their rights. And if a trust doesn't have a beneficiary, it collapses. A trust without a beneficiary is a nullity, a very important issue. So if no beneficiary, the amendment of inter vivos trust, very important. If no beneficiary has accepted any benefits from a trust, then the founder and the trustees may amend the terms of the trustee. They can make any changes they want. They can remove a beneficiary. They can make any amendments that they choose. They can even amend a clause that prohibits an amendment. So in other words, if there's a clause that prohibits an amendment, they will take that clause out first, then they can make whatever changes they want. So if no beneficiary has accepted any benefits of a trust, what is the issue with a beneficiary accepting the benefits of a trust? If a beneficiary accepts benefits of a trust, they become party to that contract. I'm talking about an inter vivos trust here. They become party to that contract because they've accepted the benefits. Basically, it's a contract in favor of the third party, which is the beneficiary. The beneficiary now accepts that benefit and becomes party to the trust. And what happens then, if a beneficiary has accepted benefits from a trust, then such a beneficiary must be party to the amendment. But it's a huge but. If the trust deed specifically provides that the consent of beneficiaries is not necessary, then their consent is not necessary even if they have accepted the benefits of the trust. Why? Because they've accepted the benefits of the trust, but the trust itself says that the consent of beneficiaries is not necessary. So therefore, they can only accept their rights as provided for in that trust deed. So in Potgieter's case, the trust deed made changes. Capital beneficiaries were increased to include a new wife and her children. The income beneficiaries were also changed now, and they all became discretionary. The changes were made without the consent or knowledge of the original beneficiaries. Did they have to give their consent, the original beneficiaries? Basically, Clause 2 specifically provides that trustees may amend the capital beneficiaries of the trust. But the deed did not provide that an amendment could be made without the consent of the beneficiaries. The trustees may amend. Therefore, the common law rule in Potgieter's case applied because the consent of beneficiaries, they had accepted the benefits and therefore their consent was required. Because it said the trustees may amend the capital beneficiaries of the trust, but the deed did not provide that they can be made without the consent of the beneficiaries. The logic, an inter vivos trust is a contract. A contract has terms. A beneficiary accepts the whole of the trust deed, and if the trust deed provides that the consent of beneficiaries is not necessary, then the beneficiaries accept this too, which has happened in a very recent case, and that is in Jabir and others. The court held it's the very nature of a contract in favor of a third party. In other words, a stipulatio alti, contract in favor of the third party, that the third party who accepts the benefit of the contract cannot do so selectively, but also to any limitations and or onerous provisions. So if a beneficiary accepts the benefits of a trust and the trust deed says that benefits can be varied, they accept that as well. They accept that. So that's a very important court case, the Joubert case, because it qualifies what Stonder's case said. So basically, in this case, the trustee reserved to the founder and trustees a wide power of variation, and therefore the beneficiaries accepted their benefits subject to that limitations. Their benefits could be diminished or perhaps even lost pursuant to a subsequent variation in the trustee. So it's a very important clause. How do people accept benefits? Acceptance of benefits need not be formal acceptance, but can be by conduct. The fact that a beneficiary is staying on a trust property may also constitute the acceptance of trust benefits. And a beneficiary can accept even contingent rights, a very important issue. And basically, in Ross's case, it's not without relevance that the respondent alleged that she conducted part-time operations on the farm. These facts are consistent with her having accepted the beneficiaries of the trust. What does this mean? It means the trustees could not alter their trust without her permission. The court and the amendment of trustees, Section 13, a court has a wide discretion, including an order terminating a trust. But it's very important to point out that an application to court under Section 13 is only necessary when the founder of a trust is no longer available to consider an amendment to the trust, because the founder is part of a contract. And the important thing is it's not easy to succeed under Section 13, because there are two requirements. I've put them on the screen. I won't read through it, but there are two requirements. They must both be present. Then only if they're both present, a court has powers including amending or terminating the trust. In this case, Harvey N.O., Supreme Court of Appeal case, an amendment application was brought in terms of Section 13. Application was made to the court for the deed to be amended, declaring the word children, descendants, issue legal descendants to include adopted children. Remember, we looked at this case earlier. The court held the object of the donor was clearly to provide income to his children and capital to their descendants. The language used had that effect, and therefore you can't come under Section 13 and say the relevant provisions hampered the achievement of the object, because the achievement was achieved. The court also found that the relevant provisions were not in conflict with public interest. The court found it did not prejudice the interests of beneficiaries, and therefore it's doubtful whether it was the means by which non-beneficiaries can seek to be made beneficiaries. So therefore, this application under Section 13 fails. And the important principle is the court held that the South African courts enjoy no general jurisdiction to authorization of a variation of the terms of a will or trust. It's only recognized that effect will not be given to a provision that is contrary to public policy. So therefore, a so-called out-and-out inheritance clause cannot be challenged on constitutional grounds. And the testator's freedom of testation should have priority in this situation. And I'm very happy at this stage to take any questions.
Thank you, Professor Geach, for I think giving us all a lot of food for thoughts. I know it's not an easy task to try to condense such a complicated area into 45 minutes, but thanks a lot for all that information. There's some excellent questions that have come through. The one I was hoping you could just touch on, and it's a common question I think that arises in terms of choosing your independent trustee. What is the extent of the other connection in terms of an independent trustee? And how close is too close, and how far away does a person need to be? And specifically, what about, say, a friend or colleague who is not a family member or a beneficiary? Would they be able to act as independent?
A friend or colleague would be capable of acting as independent, provided they're not directly or indirectly a beneficiary, and provided they're not under some sort of obligation to the other parties. Okay. So it does not have to be a professional person, in other words. No, it doesn't have to be.
Thank you. Here's an interesting question from Lizelle Kilborn. In a recent case, and I tried to, while you were talking, find out which case this was, but I wasn't successful. Certain trustees refused to give information about the trust's finances to the beneficiaries. The beneficiaries then apparently submitted a request in terms of the Promotion of Access to Information Act, which was refused, saying that this act does not apply to trusts. This is clearly against the spirit of the act, but interpretation of the definition of person was used as the excuse. Do you have any comments on the applicability of this act to the trust?
Yes.
Or
Yes, that case is correctly decided, and what you just said has summarized exactly what it says, and it is correct. That's quite right.
What is that? I mean, what does that mean practically? Does that mean Promotion of Access to Information Act just does not apply to?
It depends on each circumstance of each case. You'd have to see whether it applied or not.
Okay, excellent. And then perhaps the last question. I mean, you spoke a lot about the rights of discretionary beneficiaries, but from a tax perspective, I mean, if discretionary beneficiaries are changed or if beneficiaries are added, does that give rise to potential value shifting or any other tax consequences?
Graham, your comment is quite correct. Tax issues are very different. There won't be, you're quite entitled to change beneficiaries if they're discretionary from a tax point of view, and there would be no limitation on that whatsoever.
Thanks. Yeah,
so,
I think something to just bear in mind is that, and you mentioned it earlier that discretionary beneficiaries, although they have discretionary rights, there are still rights. So I know that we come across from a tax perspective cases sometimes where someone will sell their rights, and that certainly would give rise to a tax consequence. And often something that's also overlooked, I think, is with trusts that hold properties. I believe that if the beneficiaries are changed, there may be a transfer duty implication on that.
In fact, there's no doubt whatsoever that if beneficiaries are changed, there will definitely be transfer duty implications. We've got quite a bit of case law on that.
Excellent. This is an interesting question relating to religious freedom. Is there religious freedom to nominate beneficiaries belonging only to a specified faith? For example, could you limit your beneficiaries just to, for example, educational bursaries for the Jewish faith or for Catholic faith or anything like that? Or would that be deemed to be unconstitutional?
Each case depends on its own, but where they have tried to limit the class of beneficiary, it has been held to be unconstitutional. There have been quite a few cases on that where they said that you were discriminating against certain races or religions or whatever it may be, and you would not be allowed to do that.
Interesting.
Okay, there are quite a few cases on that. Yeah, there are quite a few cases on that.
The questions are coming through thick and fast. I'm gonna keep asking a few, and I mean our time is effectively up, so people are welcome to leave if they like. But I'm gonna keep going with a few questions if you don't mind. With regards to the legal nature of awards made by trustees of a discretionary trust to one or more beneficiaries, do you think it could potentially be seen to be a donation, an act motivated by sheer disinterested liberality?
It's a specific exemption in terms of the donations tax sections. It's a specific exemption from that.
Okay, interesting.
The interesting thing with distributions is when you allocate but don't pay, there's a lot of attention that needs to be taken with those sort of transactions, just by way of aside. Yeah, I didn't touch on it today, but it's quite an important issue.
Okay.
Because obviously sometimes you would like to, you don't want the trust to be taxed, but you would like a natural person or series of natural person beneficiaries to be taxed, but you don't necessarily want to make an actual distribution. So there are quite a lot of issues that need to be taken into account there. And not least, you've got to look at the 7C implications. And that's why with those resolutions, when you look at that, must be drawn up very carefully. You can escape hardship if you want to do that, where beneficiaries are taxed, but the funds still remain in the trust for asset protection, etc., etc. But you need to have more than just resolutions. You need agreements and things like that.
Okay. And then, if you could just touch on the appointments of the accounting officer. I know this question comes up quite often. I mean, if the specific scenario painted here by the question is if a person who is a trustee with two others who are not beneficiaries, but that person is a discretionary beneficiary and is also the trust accounting officer, do you think that they are at risk of that being an alter ego trust? I mean, there you have one person who's trustee, accounting officer, and beneficiary, but he does have two independent trustees as well.
Well, as soon as the trustees can make decisions for beneficiaries, and they are all the beneficiaries, then that is an alter ego type of situation, and that's a problem. But if the trustees are not all the beneficiaries, that's a different issue. As soon as you mirror trustees and the same crowd are beneficiaries, then you've got a problem, obviously. So that you need trustees and beneficiaries not to mirror image each other. Beneficiaries and trustees mustn't mirror image each other. Otherwise, you've got a problem. Because that could even be seen. That can be seen as a partnership, and in practice, it has been seen as a partnership.
Oh, interesting. So, but I mean, the appointment of that person as the accounting officer is less important than, you know, the fact that he's a trustee.
No, a person can be a trustee and the accounting officer. That's absolutely right. But it's when you mirror image trustees and beneficiaries, and there's no difference, then you've got real problems.
Okay. All right. Okay, I'm just going to limit it to two more questions here. The one is, can a beneficiary give up his or her right to any future income from the trust to another individual without the consent of the trustees? So can a beneficiary effectively cede their discretionary right to someone else without the consent of the beneficiaries?
It depends entirely on what the trust deed says. And generally speaking, if you are a discretionary beneficiary and you so-called cede those rights, then you're ceding those to somebody who's not necessarily named as a beneficiary. So I would say you can't do that. That's off the top of my head straight away. That's the way I'd answer that.
All right, and then, sorry, what is the position where trust assets are held in a company and the beneficiaries of the trust, or perhaps the trustees of the trust, control the board of such company?
I'm sorry, is the trust a shareholder in that company? I'm sorry, I just didn't quite understand the question.
The trust would be shareholder in the company, and the trustees of the trust control the board of the company, and the beneficiaries.
I can't at first sight see anything wrong with that.
Yeah.
They're acting in different capacities.
Okay, so the important thing is to just clarify their specific roles.
Yes.
Okay.
And be very clear in what role you're acting at any particular time. Okay. There's obviously potential conflicts, you know, as long as, because the common law principles apply very much with trusts and common law and company law for that matter. The common law applies. So you must just make sure there's no conflict of interests and things like that.
I think the important thing is to obviously just, as you've said throughout the presentation, just have the relevant legal agreements in place and the correct authorities designated to
in fact, I'm quite horrified in practice how many trustees fail to actually keep documents and contracts and distributions, decisions making distributions and decisions making the right to use assets and loan accounts and things like that. As you saw in my presentation just now, I mean, that whole case was, is this a donation or what is it? Is it a loan? Is it a donation? What is it? A sale resulting in a loan? Or what is it? I mean, basic stuff like that we should always have on record.
Okay, last question, Prof. Geach. This is quite a specific one. If assume a husband has a lifelong maintenance order to his ex-wife, but he gets remarried and puts his new house in the name of a trust with his second wife as a beneficiary. If he passes, would his ex-wife have any claim? I mean, it would depend on the divorce order as well, but would you
I'm assuming he's forming a new trust, completely new trust, and when he gets remarried and there's a new asset that goes into that new trust.
Yeah.
There won't be any connection really if his divorce is through, and the ex-wife wouldn't be a beneficiary of the new trust in any way.
Yeah. No, I agree. All right, excellent. I think that wraps everything up. Thank you very much once again, Professor Geach, for your time. Thanks everyone for attending. What we will do is we'll follow this. We'll follow up after this with the recording of the webinar, and as well as our contact details should you have any questions or any queries or like to find out anything more. But you're welcome to leave the meeting room now, and thank you very much for your time this Thursday morning.
Thank you, everybody, and thank you, Graham.
All right.